So let's get started. Good morning, and welcome to the third day of the Whiteness Property Symposium. My name is Maya Garza. I am a 4L here at the law school, and I'm really excited about today's panel, Whiteness and Criminal Justice. There's a whole lot of different sort of avenues that we can look at whiteness and criminal justice, and I think our panelists are going to be talking about a whole bunch of different super cool things. And so I'm going to be very short and introduce everybody, and we're going to move on. So we're going to start with Jay Borchert, who's a PhD candidate at the University of Michigan, and then Jamila Jefferson-Jones, who's an associate professor at the Barry University Delano Andrea School of Law. Next will be Andrea Roth, who's an assistant professor of law at UC Berkeley. And then we'll end with Priscilla Ocen, who's an associate professor of law at Loyola. Cool.
So, let's get started here. Okay, cool. So, as Maya said, I'm Jay Borchert, and I'm a PhD candidate at the University of Michigan Department of Sociology, and I've been a visiting scholar at the Center for the Study of Law and Society at Berkeley for last year and this year as well. But most importantly, I think for my talk, if we're talking about identities, I'm a former prisoner. And I spent 7 years locked up in Minnesota, California, and Illinois. And I think it's important because one of the things I dislike the most about some prison research and just research on marginalized populations in general is this idea that academics come in and kind of colonize people's social problems for their own personal and professional gain. And without taking a serious critical look at the consequences that their research findings might perpetrate on those communities. And this graph is to kind of explain some of that. So there's a very prominent sociologist, who I will not name, at a prominent school. And this piece came up in the American Sociological Review. And essentially, we have a graph of whites and blacks and what their kind of status in the community, their well-being was prior to incarceration. So we say that whites were in the aggregate at a 5. And because of incarceration, they dropped down to 2. So they had a 3-point drop. But blacks were at a 3 and they dropped to 1. So they had a 2-point drop. So his takeaway was that prison was worse for white people. And I asked him at a RWJ Robert Wood Johnson colloquia, I said, well, so what are you doing to ensure that this isn't taken by people to promote kind of this colorblind racism that's going on that Michelle Alexander talks about so much? He said, well, the university is not incentivizing that, so I'm not doing anything about it. And, oh, Jesus. I need to turn this off. And I thought, this is the last, you are exactly who I don't want to be in life. So if you ever see me doing something like that, call me out. I mean, these are the types of things that can perpetrate real damages, and prison sucks for everyone. But to say that somehow it sucks more for white people, it just doesn't bear out in the data that we have. So I just wanted to bring that up. So we all know pretty well the statistics about mass or hyper-incarceration, that we incarcerate the most people in the world, that there are vast racial and socioeconomic disparities among who we apply our criminal justice system to. We've had 3 eras in prison history since Reconstruction, starting with the hands-off era in 1871, which really defined prisoners as slaves of the state during the time that they were incarcerated. This lasted until about 1961, when the federal court started to view prisons as within the purview of constitutional protections. So the 8th Amendment and the 14th Amendment started being applied to prison law cases at that time. And in concurrence with the civil rights era, we had some gradual changes to conditions of confinement. In 1974, the Precunier versus Martinez case extended explicitly constitutional protections to prisoners. We then, towards the end of the 70s, with the kind of war on drugs and war on crime, took a turn away from constitutional protections for prisoners, and we entered this era of mass or hyper-incarceration within the punitive term. And there are a number of cases that are associated with that. It was a closing, that marked a closing of the prison as a prominent research site in sociology. Research then focused on re-entry and the kind of collateral consequences of incarceration as opposed to what's going on inside the prison itself. It generated an era of invisibility for U.S. prisoners, and throughout prison research and just our prison practice and orthodoxy, there's this distorting prism of whiteness that that places this legitimated white gaze upon delegitimated black, brown, LGBT, and low SES bodies that disproportionately inhabit our jails and prisons. So there are 4 prominent features within the punitive term. We have mandatory minimum sentences and sentencing guidelines. We have the judicial doctrine of due deference, which grew out of a set of cases in the Rehnquist court starting in 1977, which was fully then articulated in Turner versus Safley in 1987, which took conditions of confinement cases from strict review to rational basis review, and also kind of removed officially constitutional protections for prisoners if there was a legitimate penological interest for the prison policy at questioning court. My point is that deference is a linchpin that locks down the punitive term. It's the hallmark of the era of incapacitation. We then moved on to 1996 and had the Prison Litigation Reform Act, which ordered prisoners to address their concerns at the local level to exhaust internal due process requirements within the prison. However, if we take the Prison Litigation Reform Act out of the equation, we're still left with deference. So, for me, deference is the guiding force for the era of incapacitation. Together, they act as the tools that complete the new Jim Crow that Michelle Alexander talks about, and law in the book structures the way that citizens can legally move through society. Law in action defines and categorizes transgressions of the law, appropriate punishments, as well as who can gain relief from troubling conditions of confinement. Why is this important? It's about who owns and gets to officially tell the story of American punishment in prisons. Reform era prisoner narratives and reports had unexpected uniformity across disparate institutional settings, political regimes, and prison cultures, and thus demonstrated harmful conditions of confinement that had been hidden during the hands-off era and motivated the court to intervention during the prison reform era. And we know that from Malcolm Feely and Ed Rubin's amazing work. So deference plus the PLRA equals an era of invisibility, delegitimating prisoners' lived experiences, reifying white notions of a valid, reliable criminal justice system, and rendering prisoners virtually powerless to gain relief. And when relief is gained, it's often problematic. So some people view realignment as relief. It's essentially not relief, because those in opposition to the carceral state had one place to go before realignment. They went to Sacramento. Now we have all the counties in California. So it dispersed opposition to the carceral state in California. And I think that's highly problematic. It took the power away from prison reformers and abolitionists. So for deference in action, who are the primary objects of deference? Do the objects of deference support its epistemology? Do the objects of deference believe that it works? What troubles the validity of deference according to these officials? Giovanna Shea writes that corrections is not an undifferentiated monolith. It does not have an identifiable, discrete, isolable, operational, uniform epistemology across all those considerations, domains that we can reliably or validly count on to guide judicial decision-making in prison law cases. Sharon Dalovich writes that this lack of review is an abdication of responsibility by the judiciary that potentially fragments the field into 51 disparate correctional regimes by state. So why are prisons so special that deference is required? That's a good question. That's a good question, because many other scholars who write on deference note the complicated cases that the judiciary otherwise takes on. So why is prison so complicated that these questions are not answerable, or they're not able to judge these cases? Some of the major prison law cases over the last 20 years have exhausted the judiciary's patience for deference, trouble it, and along with the advent of PREA, significantly problematized the doctrine. So, as I said before, Plata is one of those, Batista versus Clark, which is a Massachusetts case about a transgender inmate, Neal versus Michigan, which is a large class action case about abusing female prisoners in the Michigan prison system, and Johnson versus Texas is a case of an inmate who was repeatedly exposed to sexual assault and rape over time, and ignited claims of deliberate indifference. So, after a flurry of correctional law activity, the development of prisoners' rights has been brought to a dramatic halt. And that trend toward innovative judicial intervention in correctional problems has been replaced by a pattern of renewed disinterest in the legal concerns of inmates. The result is that a penal institution may as easily justify an inmate to suffer physical side effects from drugs as to justify forcing an inmate to conform to a grooming or dress code. And institutional security, discipline, and rehabilitation can easily be cited in support of virtually any regulation unless there is some strong evidence to suggest that the governmental interest is not legitimate. The court is unlikely to look beyond the face of the stated interest to see if the underlying policy is arbitrary or irrational, or if the regulation truly furthers those interests. So the judiciary, in essence, is suggesting that some other decision maker actually possesses important information, experience, and skills that will help it decide some relevant question correctly, and they're suggesting that the other decision maker is not just a good one, it's also a superior decision maker relative to the court. And Horowitz writes that the court is thus providing epistemic authority to prison officials, despite the vast differences between prison officials and the regimes that they manage. So, in so doing, the court has isolated inmates from the body politic by positing that Turner test or rational basis standard of review applies in all circumstances in which the needs of prison administration implicate constitutional rights. Administering prisoner rights through the construction of highly subjective decision-making criteria that are in and of themselves highly problematic for valid decision-making in prison law cases. Citizenship rights, human rights, can each be seen as property not available to those who have transgressed the low-level boundaries in what make up the vast majority of our prisoners, low-level drug cases, yet remain available to the primarily white elite who transgress substantial boundaries, for example, in financial crimes. So scholars questions whether prisons can be managed with decency without robust judicial review. And again, in so doing, have a tendency to fragment. Courts throughout the 1990s encountered flagrant abuses of inmates. These included cross-gender strip searches in non-emergency situations, hiring staff previously convicted of unlawfully beating inmates, withholding medication for an inmate known to be HIV positive, confining an inmate in a strip cell for approximately 20 days, where he wrapped himself in toilet paper to keep warm, and crowding of up to 190 inmates in a facility designated for 51 persons. And while judicial intervention has remedied many abuses, the end of judicial oversight often results in backsliding. So I'm going to just kind of skip through some of these slides. So, prison sociology has not fully investigated the role of deference as a political technology of the body that structures the outcomes for millions of citizens. Feely and Rubin, Jonathan Simon do not focus extensively on deference, yet legal writing builds on core sociological foundations, including symbolic, materialist, structural, and cultural critiques of the prison and punishment state. Jonathan Simon asks us to determine the precise relationship between changing forms of punishment and developments in the available schemas for coordinating and controlling human bodies to produce power or political authority. In this case, it's deference to correctional expertise that is that particular schema. So the plan is that I was going to go in and interview the highest level correctional officials nationwide to determine what they believe about deference. Why? Because they're the primary objects of that deference. Who? State level executives of state departments of corrections. I went in and I gained access to 23 states nationwide in each region of the United States. The demographics of prison leadership are just as you would expect. They're remarkably white and male. There are 6 people of color and 3 women who run departments of corrections. They have various experiences going from starting in the field as a prison guard or a prison counselor and moving up through the ranks, or just being hired as a political hire from another state agency without correctional experience. But they equally, no matter their experience, have deference applied to them with the same force, right? Despite varied experience and knowledge. I did a total of 26 interviews with directors. 3 of them were with assistant directors, interviewed in a subset of states. And I did the interviewing during an 18-month period during 2013 and 2014. And I won't get into the method, but I used the heuristics of case analysis, which is made famous by Diane Vaughn, and theory abduction, which is from Timmermans here at UCLA, to kind of ground my findings. I found that the demographics alone demonstrate massive social distance between prisoners, prison officials, and the judiciary. State prisoners in the aggregate across the country are 34% white, 38% black, 21% Hispanic, and 7% everyone else combined. Correctional directors are 80% white, 11% black, 6% Hispanic, 2% Asian, 94% male, 6% female. And the federal judiciary is 74.2% white, 14.4% black, 8.6% Hispanic, and so on. So, through these demographics alone, we can see that education, income, political power, geography, neighborhood characteristics all add to the vast social distance between those who are making decisions about the legitimacy of our punishment state and those subjects who are being affected by the way we do criminal justice. Some of the things that they said: it's not our role to punish people. Taking people out of society and putting people in prison is punishment. Courts do that. We take care of them. After the courts do that, that's our job. We used to use prison and we used to send people to prison to be punished. We now understand that prison is the punishment. We need to help that prison be successful because 90-some% are going to come out. John DeLulio has this thing called the keeper's philosophy, which matches onto these philosophies, this idea that correctional department directors have, that they're actually not doing the punishment, that somehow it's the court that's enacting the punishment, even though correctional department directors are making decisions about resource allocation, programming, processes, how to use solitary confinement, all these things on the ground. They distance themselves, for a set of reasons, from their participation and their complicity in the punishment state. A failure to see that their decisions across multiple dimensions shape the form of punishment for prisoners, their lived experience, and in so doing structure overall outcomes for these prisoners. A majority of the prison officials, strangely, do not support deference. One of the things that a director said is, I think we all need to be called into question. We should always be looking in the mirror and challenging ourselves. We should always be questioned and challenged because we get too polarized and we get so locked into surviving the day-to-day world. I think being a corrections director or being involved in corrections at a high level is probably the toughest job in show business. And sometimes we get focused, we get blinders on, and I don't use the term thinking outside the box, but we certainly need a neutral third eye coming in to look at us. But there's variance here. And I wish I could identify who said these things, because that would add a whole other layer of knowledge to these findings. But I promised them confidentiality, and I have to adhere to that, unfortunately. However, there's some variance here, as I said. One director says, I believe that when it comes to daily operations, that the courts and Congress ought to listen to what correctional administrators are saying to them, more so than some passionate advocates, because I've seen people at other ends of the spectrum, advocates who begin to advocate for a cause and see the sky as the limit in terms of how overboard they're allowed to go. And this same director, and this is a long quote, but it's an important one, went on to say, there are offenders who know very well how to play the system. Serial offenders within the system that know how to play up to advocates. They are articulate, but when they go disclose and advocates sit down with those people, they just wreak havoc. I think the courts and others need to give deference to the administration in terms of how to deal with these people, because in a sense they encourage those behaviors from those individuals if they know that they can play the system, and then thumb their noses at everybody else in the process, and there are many different ways of doing that. You know, I knew of a guy very articulate, wrote poetry, was quite literate, and he had some folks from a university come in to see him regularly, and these people just ate at his feet, literally, and they thought he was the greatest thing that existed out there. But the minute they walked out the door, he was swearing and cursing officers, he was spitting at officers, but they could not fathom this individual behaving in this manner. But he would do it the minute he turned around, a psychopath, a psychopath. But they didn't want to believe that because he could write poetry and he was quite literate and so forth. Even judges will question whether or not, after having this guy in the court, if they should believe him or believe the warden who is describing why this guy needs to be in some form of segregation. And when that occurs, the entire system is adversely impacted because other offenders see what they can do and get away with, and all these guys are versed at doing these things. In addition to those challenges to deference, there are some internal challenges to deference, because deference is built on proximity to the scene, right, to the social space, and knowledge that's gained through proximity to prisoners. But correctional department directors don't want to defer to their wardens, who are not at headquarters, but who are actually managing prisons, right? So deference has a particular location, and that's between the state level Department of Corrections and the federal court that's going in to make decisions about proper conditions of confinement. So I say that I do think absolute power can also corrupt absolutely, so I don't think necessarily that it's a bad thing that there are looks and quality control. We've seen in the years that I've been around, we've seen things that have been done improperly. I have the same thing with institutions. I'm the commissioner and every warden wants to run his facility, but they do know I'm the commissioner and I'm going to come down and ask some questions, and that's okay. But would they prefer they just ran it and I never asked a question? Yeah, that's just human nature. I think it's okay to set the framework. I do, and I think it's okay to see how it's being done at times. Because you have different cultures. The state is very different from the eastern to the central to the western part of the state. And so you really have to be familiar with what the culture is and how you present a rule there, and then in how you make sure that it has been implemented in the way that you want it, and you get some quality control that goes on. So we also know that, and I'm very close to being done, we also know that the political landscape troubles deference. There are constant struggles for scarce races with more worthy candidates, such as children, the elderly, anything but prisoners, almost anything, you know. People are more worthy generally in every domain except for prisoners when it comes to resource allocation according to our government. And one director says, I think politically the polarization of the political parties has had an adverse effect on corrections. And I think the excellent business plan of private prisons, where they start at the top and work their way down to where they contribute to inaugural events for governors and contribute to campaigns and contribute to causes that are dear and near to the heart of elected officials, is an issue. I don't know of any correctional director in the U.S. that thinks, well, we really need to privatize the prison system. That's usually a decision that's made at the political level, and I think people are starting to pay attention to that on a national scale. So in conclusion, I have a lot more data, but just briefly, the data supports Shea's claim that corrections is not a non-differentiated monolith and thus requires strict review at court. Political, cultural, epistemological, and structural variance between the states and among institutions within states warrant strict review. Even those who don't support deference, even those who do support deference don't support it within their own departments. This troubles the logic of deference as constructed on the epistemic authority of proximity to prisoners and specialization in corrections. Deference is thus an evasion of judicial responsibility, following Sharon Dolovich's claim, and is an invalid, unreliable, and highly subjective tool to organize the penal field when so many millions of citizens are implicated. Deference is a decivilizing process and is counterproductive is a counterproductive political technology of the body. Deference has thus helped to construct an era of invisibility in prison sociology, has helped to erase the voices of people of color and low SES people, both during and post-incarceration, and maintains hyper-incarceration, and the new Jim Crow. Lots to unpack here. Huge amount of data to continue sifting through. Papers 1 and 2 are out to reviewers with additional papers to follow. Review of deference at the lower level among low-level prison employees, and just work to end this era of invisibility in prison sociology and re-legitimize prisoner narratives. Thank you.
Alrighty, good morning. I'm Jamila Jefferson-Jones, and I'm going to be talking about using whiteness as property to promote social justice for ex-offenders, and so, or those with ex-offender status, because I actually don't like the term for a number of reasons. And so, actually, I think this is a good follow-up to Jay's talk, and really has some synergies here. But my work uses the theoretical underpinnings of whiteness as property to examine reputation as property in the context of reentry. In particular, I reconceptualize collateral consequences of incarceration and the damage to reputation suffered by the previously convicted as a government taking for which just compensation is due. In this way, the whiteness as property concept is used to promote social justice for those with ex-offender status, a population that is disproportionately black and brown. Most current discussions of collateral consequences of criminal conviction and reentry barriers and discrimination against those with criminal records center on one of two notions. The first being fairness or the lack thereof of continued, unforeseen, or disproportional punishment, or secondly, the role of legislatures and the executive, usually in the guise of administrative agencies, usurping the sentencing function of the judiciary through the imposition of collateral consequences. I, however, am not a criminal law scholar. I'm not really a reentry scholar either. Rather, I'm a property scholar who is interested in exploring notions of property rights among people on the group and groups on the margins of society. Margins, again, that are disproportionately populated by people of color. So here I use reentry as a vehicle to explore those margins. So rather than focus on fairness or disproportionate punishment, or legislative or executive roles in sentencing policy, I posit that there's an even more powerful argument to be made against the many collateral consequences, and my argument focuses on the idea of reputation as property and reconceptualizes the damage to reputation suffered by the previously convicted as a government taking of private property for which just compensation is due. And I do this in two places. One paper that's already been published, and one, it's called A Good Name, Applying Regulatory Takings Analysis to Reputational Damage Caused by Criminal History. And in this one, it establishes continued stigma attachment as a government taking. And then the second one, which is going to be published soon, I'm editing and behind on that, but it's called A Second Chance Rebiography as Just Compensation. And there, you can see they're both published in West Virginia because they're companion pieces. And so my argument focuses, like I said, on this idea of reputation as property, reconceptualizes the damage as a taking, and I seek to tie this idea of rebiography to an actual substantive rebiography right, which would be the right of one to rewrite his or her history to make it more in line with his or her present reformed identity. And I conceptualize that as just compensation to those with ex-offender status. And so this idea, this rebiography right, stems from the inherent value of reputation as property, and thus the taking of it as constitutionally cognizable. And I further argue that such a focus renders it necessary to examine the powerful role that stigma plays in criminal punishment and the potential for destigmatization to restore reputation as status property, so to the previously convicted. So what do I mean by status property? Most simply put, status property is that property which is linked to identity. It's reputational interest that endows the owner with certain privileges, and actually I'm quoting someone here, reputational interest that endows the owner with certain privileges flowing from a public conception of their identity and personhood, and that can be analogized to conventional forms of property and literally converted to those forms. And that's from Nancy Leong's Racial Capitalism, in which she, of course, is citing Cheryl Harris's Whiteness as property. So, kind of going on, that should have been there already, but going back to first year property courses, right, when we talk about establishing a takings claim, conventional takings claims require that the claimant identify 3 elements: the property involved, and there's our takings claim there, the takings clause, I'm sorry, there, the government involved, the property involved, the governmental conduct that has resulted in the taking of the property identified, and the just compensation to which the claimant is entitled. And although physical takings jurisprudence may be instructive, the regulatory taking schema is more useful in establishing the damage to reputation suffered by previously convicted as a violation of the takings clause. And this is because damage to reputation as a collateral consequence of conviction is the result of government regulations that restrict property rights in a manner that significantly diminishes the value and causes substantial but arguably compensable harm to the affected individual. A takings analysis that analogizes the collateral consequences of stigma attachment and continued reputational damage to an impermissible taking must then first establish reputation as cognizable private property under the takings clause of the Fifth Amendment. So in exploring the property-like characteristics of whiteness, Harris acknowledges the debate regarding whether reputation is more properly cast as property or liberty, but decides that reputation is a melange lending itself to different descriptions over time. I instead conclude that rather than a melange, reputation bears the same characteristics as whiteness, and therefore also qualifies as status property. So once reputation is established as property, then the government conduct can be identified as the continued assault on reputation by the ongoing attachment of stigma, even after one's sentence has been served. And I say all that to say that Cheryl Harris's Whiteness as Property gave me the language and the structural framework with which to articulate this idea. And I know a number of us have done close readings of that work, and you'll remember that in part 2C of Whiteness as Property, she delves into the critical characteristics of property and whiteness, laying them side by side to show that in cases of status as property, thingification was wrong-headed and tangibility unnecessary. As Peggy Rady has noted a couple of times this weekend, if it walks like a duck and quacks like a duck, then apparently it is one. So, just to review, you'll remember that this is how Part 2C accomplishes that feat, by laying out property and whiteness side by side. So she looks at whiteness as a traditional form of property, the modern views of property as defining social relations, property and expectations, and then the property functions of whiteness, focusing on the bundle of sticks of rights of disposition, rights to use and enjoyment, reputation as status property, and the absolute right to exclude. Basically, I just totally followed this blueprint, except that C comes out because my argument is that reputation is no different than any other type of status property. So I don't need to talk about reputation as status property, but instead plug it into each of these categories here. So what Harris does is charts the evolution of whiteness from racial identity to status, and then to property. And she says that whiteness focuses variously as identity, status, and property, sometimes singularly, sometimes in tandem. By contrast, ex-offender status is by definition a legal status. And rather than evolving from identity into a legal status, the evolutionary trajectory that it follows is from legal status to an aspect of identity, and it's this identity functioning sometimes singularly, sometimes in tandem with the legal status that impacts the previously convicted person's property interest in her reputation. So if we go back, which I should have done on this slide, there we go. We go back and lay those things side by side. I can talk about reputation in each of these areas and then go ahead and wrap up. So you'll remember that the classical liberal view of property is that property ownership, individuality, and freedom are necessarily connected. And this idea is reflected in the personhood theory of property, explicated by Peggy Radin and others. Reputation as property fits within this conception. As status and identity merge, as has been the case with regard to ex-offender status, to create what is termed as a master status, one that affects all aspects of life. The person with that status, that person's liberty is constrained as the status does impact all of those areas of life. And ex-offender status serves as what can be termed as a negative credential. That is officially bestowed upon its bearer or carrier by the criminal justice system, rather than enabling access and upward mobility, as is the case with positive credentials, such as college degrees, professional licenses, and the like. Negative credentials are those official markers that restrict access and opportunity. Thus, they restrict personal liberty. Moreover, because reputation itself can be classed as a status property, and ex-offender status can be characterized as a negative credential, ongoing attachment of reputation marred by this negative credential represents one's having been depropertied of beneficial reputation or the ability to rehabilitate poor reputation post-incarceration. Just as Cheryl Harris said, owning white identity as property affirmed the self-identity and liberty of whites, and conversely denied the self-identity and liberty of blacks. Owning the negative credential of reputation that is sullied by ex-offender status denies the self-identity and liberty of the formerly incarcerated. Moreover, as with whiteness, reputation as status property has the power to grant access to a whole set of public and private privileges and that materially and permanently guarantee basic subsistence needs and therefore survival, thus increasing the possibility of controlling critical aspects of one's life rather than being the object of domination. So thus, reputation as both object property and attribute property is intimately intertwined with liberty. So we can see there where reputation fits in as a traditional form of property. Now, with regard to modern views of property as defining social relations, if we contrast that to classical property theory, which defines property as that to which value has been ascribed, modern property focuses on the function of property and the social context surrounding that function. As such, many modern theorists see property rights as contingent rather than natural. As Harris notes, this construction directs attention toward issues of relative power and social relations inherent in any definition of property. And so this notion is powerful in the context of the continued attachment of ex-offender stigma through status, and impositioning reputation as property. Property does not have any meaning outside of society. Therefore, as a master status governed by collateral consequences, ex-offender status and its attendant degraded reputation loses its meaning when it's removed from the social context and when it's divorced from the function that such reputation performs in the daily life of the person bearing ex-offender status. So in its current social context, however, ex-offender status functions as a stigmatizing attribute property that prescribes the carrier's social, economic, civic relations. Because it's not naturally ascribed, but rather attached through negative credentialing, it fits squarely within modern descriptions of property as a contingent creation of government entities and of society. We can move on and look at property as expectations really quickly. What's my time?
You have 5 minutes.
Oh, cool. Alrighty. So, Munzer notes that property makes possible legal expectations with respect to things. Harris opines that this theory does not suggest that all value or all expectations give rise to property, but those expectations in tangible or intangible things that are valued and protected by law are property. Thus, the law's current recognition of the value of reputation provides a really strong case for the legal treatment of reputation as valuable status property. And for example, we can look at the area of torts. There's the interest in reputation that's recognized in the cause of action of defamation, for example. Some may argue that only the wrongfully accused, therefore, should be able to avail themselves of some sort of restored reputation. But for those who actually were convicted of a crime, although they do not bear stigma in error, they nonetheless suffer from ongoing reputational harm of the type routinely recognized by the law. And the legal treatment of reputation in one context creates a bridge of expectation of property rights and reputation and in other contexts. So therefore, even though property and expectations may not be fully equivalent, expectations are part of the psychological dimension of property. And then finally, let's just talk briefly about that bundle of sticks. When one compares each of the sticks in the bundle of rights to the function of reputation, it also becomes apparent that reputation is, in fact, property. We can look at rights of disposition. Harris notes that in the case of whiteness, its inalienability may be more indicative of its perceived enhanced value rather than its disqualification as property. Arguably, this is true of all inalienable status property, including reputation. With regard to use and enjoyment, in the context of establishing the property functions of reputation, the narrow definition of use, which refers to the owner's personal use and enjoyment of the thing owned, applies as well as to the other incidents of use that have been identified, namely the right to manage, the manner in which the thing owned is used and by whom it's used, and the right to income as expressed by reaping the benefits of said use. And so the importance of rights in the use and enjoyment of one's reputation are already reflected in the law. They're reflected in legal principles surrounding goodwill in the corporate arena, as well as some privacy-related claims. So again, as an attribute type of property, reputation, like other types of status property, for example, whiteness, can both be experienced and deployed as a resource. Those bearing ex-offender status do experience their status daily through the imposition of myriad collateral consequences affecting meaningful areas of their lives, and they are barred, however, from rehabilitating their reputations in a manner that will allow them to deploy that reputation as a beneficial resource. Thus, once again, the potential value of this status property is subverted in this context. finally, we can talk about the absolute right to exclude. Harris notes that a conceptual nucleus of property is the right to exclude, calling it a critical characteristic of property. And she explains, when talking about whiteness, that possessors of whiteness were granted the legal right to exclude others from the privileges inherent in whiteness. The use and possession of reputation, as I explained a little earlier, adheres to the same principle of exclusion. However, as a negative credential, ex-offender status and the attendant damaged reputation represents a perversion of this concept, where one is able to exclude others from appropriating or otherwise damaging one's good reputation. In the context of ex-offender stigmatization, it is the possessor of the negative credential who is being excluded from the possibility of acquiring good or better reputation. In either case, it's clear that reputation as status property presents opportunities for its possessor to avail herself of the absolute right to exclude or to experience being excluded absolutely from its benefits. And so in this way, whiteness as property, in papers that I've written, and I think it gives an opportunity in other places, can be used to show that other statuses are also property, thereby opening the door to empowering other marginalized groups, and in this case, in the context I'm using it in, those with ex-offender status.
So for a while I've been interested in how the use of machines and technologically sophisticated forms of proof is changing criminal justice, and in crime detection and proof. And there's been a backlash against mechanization, often from civil libertarians on privacy grounds, from legal scholars in courts on grounds that mechanical and statistical evidence, when it takes the place of more old-fashioned human testimony and human witnesses and decision-making, is dehumanizing. And so what this always reminds me of is the Luddites. And what I didn't know about the Luddites, I always used the term Luddite, but I never really knew what it meant. So aside from the fact that they were this group of artisanal weavers in early 1800s in England, who smashed newly invented power looms to try to protect their artisanal weaving industry, was that many of them were xenophobic or explicitly racist. So they saw machines as democratizing in a bad way. They were concerned about their guild, their closed world of white privilege. They didn't want it to be opened up to immigrants, for example. Or to put it in Cheryl Harris's terms, they had a property interest in their whiteness. And they had a reason to cling to the status quo through an ostensibly neutral, pro-artisan, anti-machine stance. And of course, mechanization can entrench privilege and make oppression easier. Think the cotton gin, etc. And so I realized that it's complicated. And so I wanted to use the Luddites and whiteness as property sort of in the way that Jamila had just described, as a metaphor or lens through which to think about machines and criminal justice and white privilege. And so what I mean to capture by this phrase, artisanal criminal justice, if you will, is old forms of policing and of criminal adjudication and proof that rely on human witnesses to relate them and human jurors to assess them. And so I'm going to claim that this type of artisanal criminal justice, which is privileged by our legal doctrines, privileges white people particularly. And that part is going to be pretty, is nearly too obvious to state, but I just want to make sure that we have the vocabulary here and we're on the same page. So these forms of artisanal proof obviously privilege whites. We have eyewitness identification, cross-racial identification is clearly more error-prone. We have more coerced confessions. Sorry, I've got offended. My apologies here that you won't see what's supposed to be underneath there. It's pictures of those of black suspects who had coerced confessions, who were found guilty, later exonerated once they realized it was false confessions, and generally they were exonerated by DNA. And forms of artisanal policing as well. So individualized suspicion based on hunches and officer experience and subjective determinations. So think driving while black, think New York's stop and frisk policy, clearly something that has an ostensibly neutral legal standard, reasonable articulable suspicion, but clearly disproportionately affects people of color because human police officers are the ones who are deciding when it exists. And even when there's objectivity in terms of probable cause for a traffic offense, blacks are stopped more, and this is entirely legal under Red versus United States. Okay, so in turn, we have artisanal methods of adjudication. And when you have human jurors assessing the credibility of human witnesses, this also entrenches white privilege. So we no longer have these explicitly racist competence laws. This is, Louisiana, 1857. A free colored person is competent as a witness, but may, according to the circumstances, diminish the extent of his credibility. So this is how jurors were actually instructed back in the day. And so while we no longer have these explicitly racist competence laws, we do have what social scientists call a demeanor gap in cross-racial demeanor evaluation of witnesses. So thus, witnesses of color don't have to just contend with Atticus Finch's truism that when it's a white man's word against a black man's, the white man always wins. But also with the truism that when it's the state against a black man or a black victim against a silent white defendant, even a defendant who doesn't take the stand, the person of color is already at a disadvantage. So the case in point in the last couple of years might be Rachel Gentile, the 19-year-old high school student of Haitian descent, who's close to Trayvon Martin, who's defensive and raw and emotional on the stand, and there was lots of media attention on her as an incredible witness, in part because of the manner in which she spoke and her demeanor. It was generally thought that the fear was that white people would not believe her, not understand her, and I think this is an example of the demeanor gap. Okay, so now, of course, this type of artisanal justice, corrected by implicitly and explicitly biased humans in small batches, if you will, is being challenged by machines. And sometimes those who are calling for mechanization are often communities of color themselves. The example that I think most generalists are familiar with is DNA. So the Innocence Project, on the Innocence Project's website, they just say, convicted by juries, exonerated by science. And you have suspects of color who want offender database, who want access to offender databases so they can point the finger at somebody else and say, I've been falsely accused. And I want to be able to run the profile from the crime scene through the database to see who the real perpetrator is. You have body-worn cameras and dash cameras. So after Ferguson, you have calls from communities of color to videotape police-citizen interactions rather than rely on police testimony of what happened. Judge Shinlin in New York, as part of the injunction after the stop and frisk policy was struck down in Floyd versus City of New York, has started to require body-worn cameras as a measure to dismantle the privilege that came from the stop and frisk policy. You have surveillance cameras and shot spotters, which are speakers that are, they're not speakers, but they're recording devices that are set up in communities that are known for having a lot of gunfire, to immediately alert the police as to where the gunfire came from and what time it was set off. And I know in Oakland, I don't know too much about other cities, but these programs are starting to not be renewed for money reasons, et cetera, and you have some communities of color saying we want them there. It's a form of surveillance, but it is seen by some as protective against under-policing of communities of color, against police violence. So if you've got surveillance cameras, police are on better behavior, and to protect against false accusations of crime. This is one of my personal favorites. This is called the E-Nose. So Bill Stuntz and others have written about about where the racial disparities in drug prosecutions come from, and it's a really complex tale, as we all know. It's not just from racial bias in charging and arrest and these awful mandatory minimum sentences, etc., but it's also in the ease of detection of urban drug crimes. And so white kids who are committing just as many offenses in terms of drug crimes are not being detected at the same amount because of the ways that police resources are being deployed. So the E-Nose is meant to detect drug molecules from pretty far away. And so this is a guy who's searching for marijuana in Colorado. So you can imagine, so Paul Butler in Let's Get Free in 2009 says that the E-Nose, he kind of, I wouldn't call him an apologist for technology, but he's got this chapter in Let's Get Free that's all about the promises of technology. So one of the things he says is the E-Nose would have the interesting and beneficial potential to equalize drug law enforcement and reduce racial disparities. So it looks like to a civil libertarian, to the ACLU, the E-Nose may very well be the enemy. It may be total Brave New World creepiness. But if you are used to being one of the usual suspects, or if you're used to being in a community of color that is disproportionately policed when it comes to drug crimes, well, the E-Nose may be an equalizing force. Okay, neuroimaging. There's a company called No Lie MRI that is sort of the new form of lie detection. So polygraphs, they're not admissible in anywhere for the most part, unless the parties agree. The neuroimaging in terms of lie detection is also basically inadmissible anywhere in the United States. In 10 years, though, that may be different. And so Paul Butler, for example, on fMRI says, maybe this is going to be the end of interrogation. Maybe we won't have as many coerced confessions because now we will have this mechanical, highly accurate way to tell what happened. There was a woman in India who was convicted of murder in part on neuroimaging evidence that showed, allegedly, that she actually had a memory of the crime. And they could see that on the brain scan. Again, Brave New World. But if the question is, you are being falsely accused through these more artisanal policing methods, maybe fMRI has an equalizing force. Okay, so the Luddites were called machine breakers. So to continue with the analogy, I think of the ACLU and those who cling to these sacrosanct particular sacrosanct doctrines that romanticize artisanal criminal justice as being the new machine breakers. They're saying, don't use the E-nose. The E-nose is not as good as police officers on the street who know what they're doing, who have the human, the small batch justice. So just as after the Luddites, mechanization has this potential for democratizing work, mechanization has the potential for democratizing criminal justice. And just as the Luddites came up with race-neutral reasons to cling to artisanal weaving, we have race-neutral doctrines that maintain white privilege by romanticizing artisanal justice. So just some examples, and again, my apologies because you can't see the lines and stuff. So there's a case so we have something called the blind deference rule. We have this legal fiction that juries are especially good at lie detecting. At credibility determinations, and we should therefore blindly defer to jury verdicts in cases that involve eyewitnesses and confessions, even where there's apparently definitive scientific or mechanical evidence on the other side. This seems neutral. Juries are good, we want to be judged by people, but it tends to hurt suspects and victims of color. So there was a guy named Juan Rivera in Illinois who was accused of raping and murdering an 11-year-old girl. There was a confession, and he went to trial twice. The convictions were overturned on other grounds, and in the meantime, there was a DNA test finally, and it definitively excluded him as a suspect. But the prosecution went forward with the case anyway, and their only argument against the DNA was, well, this 11-year-old probably was having consensual sex with other people because, after all, she was wearing red underwear when she was killed. That was their argument. So it was like the first time in history that a victims' rights group wrote an amicus brief on behalf of a criminal defendant on appeal because they thought this was so awful in terms of rape shield laws and stuff. So the jury believed the confession over the DNA. And the Illinois appellate courts were just following the blind deference rule. They said, look, I know it seems crazy that a jury wouldn't think there was at least reasonable doubt with this apparently definitive DNA test, but we've got a rule that says that if the jury believes the confession, that's the end of the matter, no matter what's on the other side. Since then, he's been exonerated, and they found allegedly the person who really did it. On the other hand, we have the Rodney King videotape. Sometimes we have race-based jury nullification on the other side. We have juries who appear not to believe what seems to the rest of the country to be a definitive videotape evidence of guilt, and white police officers are acquitted. Now, it doesn't mean we should give up these rules or have directed verdicts of guilt. My former public defender colleagues would scream if they heard that. But that does mean that our presumption that these rules are sacrosanct has consequences, and arguably entrenches white privilege. So the individualized suspicion requirement is another example. We think this is the lodestar of the Fourth Amendment. You can't stop somebody without individualized suspicion, but what you get out of that is you privilege stop and frisk policies, whereas randomized checkpoints for crime-solving purposes, oh God, no, we couldn't have that. Narcotics dogs, E-nose, etc. One of my favorite quotes from Jane Van Gogh in Defending the Dog. The costs, because narcotics dogs, nobody likes narcotics dogs, and she's saying, hold on a second. The cost of error from suspicion-driven probable cause will always fall in the subpopulation that seems suspicious. The cost from the false alerts of narcotics dogs, in contrast, are refreshingly democratic. I don't believe that with respect to narcotics dogs, which I'll talk about in a minute, but with respect to lots of other forms of mechanization, I think that's true. Let me move on to a couple of key points because I know I'm probably... Oh my goodness! Okay, the ghost in the machine. So clearly mechanization has hidden subjectivities in it, and this will be a real crash course then. Offender DNA databases. 77% of young black men in Britain are in the DNA database. It has this ostensibly race-neutral criterion of arrestees, but we all know that in constructing the identity of an arrestee, we have huge racial disparities. And some have called for universal DNA databases as a way of equalizing that, and of course the ACLU has said that's crazy. Polygraph study, there have been polygraph studies showing more false positives with respect to black Americans than white Americans, I don't know, from other countries. Surveillance, red light cameras. Yes, it's mechanized, but where are the red light cameras? There's some litigation in Chicago about the racially disparate ways in which these are. Dogs, etc. Okay, so the final point, my apologies, I thought we had 20 minutes. My final point in using whiteness as property is, so Cheryl Harris calls for affirmative action, says that it's the only way to dismantle white privilege because the idea is to imagine where people of color would be in this merit-based system, notwithstanding white privilege. So I would like you to imagine where would people of color and white people be without white privilege in terms of who is a suspect. And so I would like to imagine that equalized mechanization in terms of universal citizen databases, equalized input, meaning make sure we see the source codes of mechanization, and equalized interpretation, getting rid of the blind deference rule, etc., might be a way to dismantle white privilege with respect to unequal mechanization and artisanal justice. Okay, great. So sorry.
Well, good morning.
Good morning.
I do not have a PowerPoint, so sorry. I'm going to get the system shut down and include it. That was very dramatic. Rolling the screens. So in my time, so first let me just say thank you to everyone, to you all for being here. I know it's an early hour before the plenary, so I appreciate you all being here to listen to these wonderful panelists. I have learned so much in such a short amount of time, and so I want to thank all of my fellow panelists for your presentations. I'm going to try to keep it short so that we can have some Q&A, so we can have some engagements of all these really rich and wonderful ideas and engagements with Professor Harris's powerful work, Whiteness as Property. So, you know, a lot of folks have sort of summarized the article, so I'm not going to talk too much about it, except to say that she posits the idea of racial identity and property as obviously deeply interrelated concepts. And in particular, the thing I want to talk about is the way in which she discusses and interrogates the hybridity of blackness and the slave identity. And I want to talk about that in the context of the prison and mass incarceration, and the way in which sort of the hybridity of blackness in the context of punishment continues to exist as a form of both property and personhood. So Professor Harris says that in Whiteness as Property, slavery produced a particular mixed category of property and humanity, a hybrid possessing inherent instabilities that were reflected in its treatment and ramification by law. Again, this hybridity of property and personhood, and this exists again within the context of punishment and in the development of the punishment state in the United States, and that continues on, I contend, through the contemporary era. This hybridity was fundamental to the way in which blackness was constructed as both inferior and therefore enslavable, reducible to property. And the way in which this was done was to link blackness to evil and criminality. Criminality was essential to the subordination of blacks and to the project of enslavement. The notion is that blacks could not regulate themselves. They were irresponsible and prone to engaging in antisocial behavior, and therefore they must be wards of a superior race, therefore enslaved, therefore treated as property. So in my time, as I said, I want to draw this relationship out. This relationship between black racial identity, criminality, personhood, and property. And in doing so, I want to examine the connection between the period of chattel slavery, this foundational period, and the contemporary era of mass incarceration, noting the ways in which particular constructions of blacks as criminals continues to justify public and private exploitation of property in the context of the prison. And I want to start by talking about a case called United States versus Amy. It's an 1859 case that was decided a year after Dred Scott versus Stanford, and was authored by the same justice that wrote the majority in Dred Scott, Justice Roger Taney. It involved actually the first federal prosecution of a slave, a black woman named Amy, for a violation of a federal crime. Recall that in Dred Scott, Justice Taney authored the opinion ruling that Scott as a slave was not a citizen of the United States, and therefore cannot bring suit in federal court challenging his enslavement. In so ruling, Taney noted for the majority that blacks were considered a subordinate and inferior class of beings who had been subjugated by the dominant race. Again, the subjugation of African Americans is sort of bound up in their personhood, their irresponsibility, and in their need for dominance by whites. He went on to note that they had been regarded as beings of an inferior order and altogether unfit to associate with the white race, either as social or in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. So back to United States versus Amy. Right, this is a year after that opinion is written in Dred Scott, and Justice Taney is called upon to ride circuit at this time to hear this case, which presented a novel issue. So in this case, Amy, this black woman, had allegedly stolen a letter from a post office and was prosecuted under an 1825 federal law which provided that if any person shall steal a letter from the mail, the offender shall be imprisoned not less than 2 and not more than 10 years. Right, so this is the federal law. Amy's defense, which was tendered by her owner, in that she had no possessions or means of her own, obviously, was that as a slave, she was not a person within the meaning of the statute. Right? And secondly, that even if she was a person, and secondly, sort of following from the premise that she was not a person, if the government imposed punishment through imprisonment, it would constitute an illegal taking of the master's property. Right? So these are the two arguments premised on the notion that Amy is not a person. Right? Amy was nevertheless convicted in federal court of violating the statute. This went up on appeal. Justice Taney heard these arguments, again, that she's not a person and that if she's incarcerated, that will constitute illegal taking of the owner's property. Justice Taney disregarded those arguments and affirmed her conviction. And in affirming her conviction, Justice Taney noted her dual status as both as a person and property. Right? So she was both. According to Taney, she was a rights bearer for the purposes of punishment, property for the rest. Right? So she's not a constitutional person; she's a statutory person. I'm borrowing that from Andrea. Right? So here, Justice Taney, sitting as a circuit court judge, declared that it is true that a slave is property of the master, and it is equally true that he is not a citizen. Yet, in the eyes of the law, he is a person, and in expounding the law, we must not lose sight of the twofold character that belongs to the slave. He is a person and property, right? This hybridity that Professor Harris described. And as Paula Johnson notes, ironically, slaves came closest to personhood and equality under the law upon allegations of criminality, right, that reinforce their subordinate status. So criminality, blackness, and property continue to be bound up with one another in the contemporary era. Like Amy, The formal status of blacks as persons and citizens, right, allows the state to act upon them to punish in particular ways. But their blackness also serves to undermine any claims of humanity or rights in the context of the prison, right, in the context of conditions of confinement, which were just recently discussed to begin the panel. It undermines their claims to entitlements to as humans, their claims to humanity, their claims to decency in the context of the 8th Amendment and in the context of condition of confinement. That is, blackness is a devalued and degraded identity, one that is associated with criminality. It continues to be posed in opposition to a valorized white identity, one that's associated with law-abidingness, that sort of speaks to some of the dynamics that were just discussed by Andrea, right? And this continues to be a basis to justify both claims of property acquisition on the part of the state and to treat prisoners who are disproportionately black as the property of the state in the context of the prison. So let me talk about this in 3 ways to try to make this a slightly more concrete in the contemporary era. How do we get to Amy, right, in 1859 to Amy, let's say, in 2014? So again, we see blacks as persons, as legitimate subjects of law enforcement who are deemed to be disproportionately criminal, disproportionately subject to regulation and surveillance, and therefore disproportionately arrested, prosecuted, so on and so forth. This leads to claims by the state that we need to acquire broader swaths of land with which to house and to build prisons and house black bodies, right? This justifies claims to acquisition and exploitation of lands for prison construction and operation. Those who are then housed in those prisons subsequently are treated as disposable property, less than fully human, and treated as units for profit for both state and private enterprises. So the first point, black folks being targets of law enforcement. You know, I don't need to say much more about this point. We incarcerate the most people in the world. 2.3 million are housed in state and federal institutions. Millions more are under the supervision of the state. 40% of those people are black, and it increases depending on where you are in the state. Many of those people are women. Over 200,000 of those 2.3 million prisoners are women, and this rate has increased exponentially over the past 30 years. And I want to make a point here, although some folks say, you know, women prisoners, you know, they count for such a small number of the overall number of incarcerated. Therefore they shouldn't get as much attention. I know nobody in the room would make that claim, but just to refute that, understand that 200,000 women prisoners is larger than the whole prison population of some countries, right? So the number of women in prison is significant on its own, but it's also, again, part of this broader prison construction, this broader march to mass incarceration. And according to Michelle Alexander, the number of people in prison today exceeds the number of people who were enslaved in 1850, right, at the time that Amy, 10 years before Amy is being prosecuted. And as Ruthie Gilmore notes, this population boom serves as a justification for the exploitation of surplus land. For example, in California, as one analyst noted, in the 1980s, California entered into the biggest prison building project in the history of the world. Right, so the conceptions of black folks as inferior, as criminal, justifies this acquisition of property, valorizing whiteness. But it also justifies exploitation in a number of other ways, right? In terms of intangible property, the exploitation of prison labor, and the exploitation of white labor, right? So by state siting of prisons in particular distressed rural communities, that allows for the exploitation of surplus white labor, right? Their direction into correctional staffs, into other sort of staffs that support the prison, allows for economic development and exploitation of a white professionalized labor force. It allows for the exploitation of unused farmland. It allows the state to profit off of idle prisoners through predatory phone rates, through predatory commissary rates, through the apportionment of the census, right? Similar to the 3/5 representation clause that many have talked about, right? So their prisoners are counted for the purposes of representation, but they're not allowed to vote. And you also have nearly free prison labor. So if you go into California prisons and many of the women's prisons, as I have, they have a whole unit where women are putting together dental appliances for Medicaid patients, right? On pennies on the dollar, but just in terms of what other dental technicians would make outside of the prison context. And it also allows for the profit off of black and brown bodies through the construction and maintenance of immigration detention facilities, right? People discuss the linkage between SB 1070 and the private prison lobby that wanted to house this new population of immigration detainees. So at the same time that the state uses a sort of hybrid status of African Americans, black folks, to justify the acquisition of land and property, it also treats them as persons, right, for purposes of punishment, treated as some, but they're treated as subhuman, as property for the purposes of punishment. Warehouse and prison lacking access to constitutional rights. And this treatment reflects the profound devaluation of black folks, right? They're not treated as constitutional persons for purposes of constitutional analysis, for purposes of assertion of constitutional rights often, right? There are all of these barriers, as was discussed by Jay earlier. And so how is this expressed, right? The notion that they're more property than persons, right? This isn't the case as a formal matter. Of course, people who are incarcerated are constitutional persons, but in terms of how they experience their constitutional rights, that's something quite different. So they can't vote or exercise a number of fundamental rights for the reasons that Jay described, particularly Turner versus Safley, where administrative efficiency trumps often the expression or protection of prisoners' constitutional rights, which renders them largely inapplicable. In the context of, in the way in which the sort of devaluation of the personhood of predominantly African Americans or disproportionately African Americans is expressed is also very gendered. So you have in men's prisons, in women's prisons, subject to rampant overcrowding and violence. And often in sort of Sharon Dolovich and others have sort of talked about this, the way that notions of black masculinity allow the state to absolve themselves of doing anything about this. This is just the way that these folks are, and there's nothing that we can do about it. There's no policy that we can put in place that would stop the violence because these are violent people, right? The pervasive use of solitary confinement, the assumption of sort of superhuman strength in the face of profound isolation. In absence of human connection, represents a sort of devaluation of the humanity of people who are incarcerated. With respect to women, it's also very gendered. The use of shackling and sterilization, right? The rampant sexual abuse of women prisoners is akin to the types of experiences that Amy might have experienced as a female slave, right? Not having any control over her reproductive or sexual autonomy. This is also occurring in the context of prison. So imprisonment, mass incarceration, these are all, and the placement of blackness in the context of criminality. I think they represent the fundamental contradictions of race, personhood, property, and the way in which these sort of contradictions continue to operate to inform our prison and policing policies. They all serve to valorize whiteness as an identity category and a system of power distribution. In some, mass incarceration acts as a real and profound site for the operation of whiteness as property. Thank you.
So it's 10:30, and right on time.
Right on time.
Perfect. We can take a couple questions though, since the next talk doesn't start until 10:45. And so if anybody has a question, this would be your moment.
Yes, I guess this is primarily directed to Professor Roth, but anyone can jump in on it. What happens when the issue of the machinery of this ramping up of the machinery is also embedded in things like popular culture? So, for instance, the ways in which the plethora of these kind of police procedurals, CSI, all these Criminal Minds, and all these other, even The Wire, how the proliferation of these television shows makes everyone on the street seem or feel like they're now, part of the, behavioral detection squad or something like that. But also how this affects jury selection. In terms of once upon a time not having that kind of contamination of a potential jury pool, because now everybody's seen Law and Order, 1,000 times. Or, now, anyway, I'll stop that question.
Yeah. Well, I won't hog the answer here, but just really briefly, a couple of thoughts. One is that again, if my former public defender colleagues heard this, they would scream, but I'm sort of a fan of getting rid of peremptory strikes. And part of the reason is that it's just too damn easy to get people off the jury who have had any contacts with the criminal justice system, or I know that police lie. Oh well, get out of here then. It's like so we have this literal whitewashing of juries that I think is completely legal under current doctrine, notwithstanding Batson and all this stuff. And so I think, and I think the surveillance of low-income and communities and communities of color totally feeds into the legal ability to whitewash juries. And then with respect to popular culture and mechanization, yeah, I mean, it's super interesting. I think it also affects how people view. I think there's this fetishization of privacy. I mean, some of my best friends are in the ACLU, so I don't mean to, but I do think I do think there's this sense. Judge Kaczynski of the Ninth Circuit's so obsessed with fingerprint databases, and we're so obsessed with Snowden and the NSA. But James Foreman just had this review of this Alice Goffman book about the massive surveillance of what she calls anonymously 6th Street in Philadelphia, and how this whole group of people is being turned into fugitives and snitches. And I just think that goes under the radar. That's not really directly on point to that first part of your question, but it's what made it.
Professor Jefferson-Jones, I'm wondering if you might talk a little bit about the practical implications for the argument you're putting forward, and how creating a re-biography as just compensation might work in practical arenas, and if there's a relationship between that and kind of ideas around making education or employment or housing more accessible to people in these kind of more material ways.
Absolutely, absolutely. And I of course, just because of the limited time, couldn't get into that. But in my first paper, for example, I talk about re-biography in the employment context, which I think is where it's probably most useful and most compelling. And so we see this movement right now toward banning the box. So where one in a preliminary employment application does not have to, or the question isn't asked about criminal history. My idea goes a little further than that, because ban the box only works in the preliminary stages, and the questions are asked later on in the process, maybe at the point when one is about to receive an offer of employment. I argue that there are times when it's not necessary even to ask that question later on, and I think it's more often than not unnecessary to ask the question about criminal history in the employment process, unless what you're doing is something very sensitive, and your criminal history is related to the sensitivity of the proposed employment opportunity. And so I do think there's some practical applications in that arena. There could be practical applications in housing, and right now I have something floating around in my head that I'm supposed to also going to write soon. But it would deal with, recently, I live in Orlando, and recently the Orange County Sheriff's Department designated an apartment complex as its first crime-free multi-housing unit, certified as such. The woman who is, and she was an African-American woman, who is the manager of the property, was interviewed by the news, and she was very proud of herself and of her her apartment complex, and said, you know, we've done a number of things to get this designation. We've increased the lighting in the area. Okay, sounds great. Good, lighting. We have cleaned up a lot. We've trimmed back hedges. We've done things like that. She said, we've also, though, we don't allow any felons, as she called them, any felons to occupy apartments here. We don't take felons. And everyone's nodding and smiling, and and it was funny because the Orange County Sheriff is black, this lady, and the guy who was interviewing her. And everybody's nodding and smiling, and I'm watching the news going, what? You don't do, you what? And so I think this is another situation in which, well, how long ago did this person serve time in prison? What's been going on since then? What are they doing now? She's just doing a blanket ban on those as she called felons. Oh, and by the way, their families, their children. So now you're dispossessing all these people the right to possible affordable housing. So I think there are lots of practical applications where one could be in a position to just not have to discuss it any further. And there are instances, other countries that do this. There's the British ROA, reoffenders, I don't remember it, but it's ROA is the acronym for it, where one is allowed to not answer certain questions after a certain amount of time. And there are categories and the like, but at least it's a start and a step in the right direction.
Can I add something to that just quickly? So I'm a fifth-year graduate student. I'll be entering my sixth year. I had funding guaranteed for 5 years, so I'm looking for funding for my sixth year as I finish. And one of the things I went to do was I went on UC Berkeley's job site to look for things at like the Human Rights Center and all this stuff. And as I went through UC Berkeley's jobs, every job, even the most menial job, required a criminal background check. And when I started at the University of Michigan, I didn't require a criminal background test to teach undergrads. But now they've instituted one for GSIs. So who knows where I would be had I entered this fall instead of, but so there are so many instrumental barriers to people, even if they get a job, like can they go to school? If they get a job and go to school, can they rent an apartment? I mean, they're so connected, and yeah, it's an ugly situation.
Anybody else? I see no. Thank you all for coming. I'm sure we'll see you throughout the rest of the